Hi, everyone. Thank you for joining us today for Constangy's webinar, CCPA Compliance Check-In, Applicability Requirements and Enforcement. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time to answer your questions. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow afternoon. Today's presenters are Jordan Fischer and Sephora Rugnetta, but before I pass it over to them, we wanted to get a quick survey related to the topics we are covering today. You will see a pop-up in a couple of seconds with these questions. We will give you a bit of time to complete the questions and we'll share the results of this survey.
Great. So while you are starting the taking this poll, I'll just go ahead and introduce ourselves quickly. First of all, thank you so much for joining us today for this webinar about the compliance with the CCPA, the California Consumer Privacy Act. The CCPA is not a new law. It's been in effect for a couple of years now, but it was amended by the California Privacy Rights Act, the CPRA, and which became effective January 1st, 2023 this year. The enforcement date, though, is July 1st, less than a month away. So given the breadth of the amendments to this law, we think it's a valuable time for businesses who are subject to the CCPA to take stock of their progress that they've made, step back a little bit, do a quick check-in to confirm that their CCPA compliance program doesn't have any significant gaps that leave them vulnerable to an enforcement action. So as you can see from the agenda today, we have a lot to cover. We're going to do some quick introductions and then jump right into discussing how data is regulated in the US and globally before we then move on to review the CCPA requirements. And then we'll talk about practical approaches toward compliance with the CCPA so that the businesses that have joined us can confirm that they have what they need in place before that July 1st enforcement deadline. I'm hoping that we'll have time for questions and answers. If not, participants should feel free to reach out to Jordan and I. So on the next slide, we'll just very quickly introduce ourselves. My name is Sephora Rugnetta. I'm a partner in Constangy Cyber's Buffalo office. I've been practicing data privacy law for over 15 years now. I've had the opportunity to work as a regulator as well as a privacy officer. So I have some, it looks like we're having some sound issues. But I'll just keep going and hopefully that works itself out. As a regulator as well as a privacy officer, so I've had the opportunity to see how laws and regulations are made and to work with companies to develop privacy programs and actually implement them. For the last 15 years or so, I've worked in-house as outside counsel with companies, helping them to navigate complex state, federal, and international privacy laws. Jordan, I'll let you introduce yourself.
Thanks, Sarah. Very excited to be here to talk about the CCPA and sort of this evolution of privacy that we're seeing both in California and beyond. As Sarah said, my name is Jordan Fischer. I'm a partner with the Constangy Cyber Group out of Philadelphia. I started my privacy journey by clerking on the Court of Justice of the European Union, which is the highest court in the EU legal system. And that's where I really got to learn about privacy, learn about the various iterations of that, bringing that EU experience back to the United States. I'm now barred in California and have really been able to work with a lot of companies to understand the CCPA, the now CPRA, and all the iterations of the law, and to really work with companies to operationalize their programs, whether that's through DSARs, whether that's through privacy notices and disclosures, opt-out requirements, a lot of what we're going to be talking about today. So very excited to dive into the topic, answer questions, and really work through sort of the nuances as we head into that July 1st deadline.
Thanks, Jordan. So if we could just move on quickly to the next slide, I'd like to just provide a few minutes of background and introduction to the Constangy cyber team. Constangy, Brooks, Smith & Profit is a national law firm that focuses on compliance with employment and cybersecurity laws. Our cyber practice specifically is relatively new to Constangy, although the 40 plus attorneys who recently joined Constangy all have a significant amount of experience practicing exclusively in the area of cybersecurity and privacy law. Our cyber practices includes 3 pillars, and I think that shows in the next couple of slides. First, we focus on what we're going to talk about a little bit today, compliance advisory services. Our attorneys in this practice group works with clients to identify which privacy laws apply to their business, and we work with them to help to develop and implement compliance policies and strategies that mitigate risk through things like third-party contracting, incident preparedness, and compliance with laws like the CCPA. Constangy Cyber also has a large incident response practice group. Our incident response attorneys are available 24 hours a day, 7 days a week, to help clients as they navigate through security incidents and serve as breach counsel throughout that identification, mitigation, and remediation steps, as well as in some cases, notification. We also have experienced litigators who can assist in the event of a privacy litigation or class action breach. Jordan, I think that you're gonna field some of the next couple of slides.
Perfect. Thanks, Sarah. So let's dive into the current data privacy landscape and what it is that we're talking about. And I feel like a lot of times these terms, data security, data privacy, cybersecurity, information privacy, data governance, they are all thrown around a lot in this space. And it's always important to step back and look at those foundational principles when we're trying to understand either a new law, a new regulation, a new court decision that's come down the pike, or just how your organization is going to be approaching these various regulatory requirements. And data security and data privacy, they go hand in hand, but they really are looking at 2 distinct sides of a coin is the best way to be thinking about it. When we're talking about data security, which I think is somewhere that, especially in the United States, we've had a lot more focus on in the last decade or 2, we're talking about protecting data from unauthorized access, protecting it from some type of compromise, whether that's an internal or an external actor, malicious actors. These are things like you see those ransomwares, or making sure that we have security controls in place to make sure access controls are there. That's what we're really focusing on data security. A lot of times it's protecting the perimeter, protecting access controls, putting up those roadblocks so that malicious actors can't get access to the information. And you need data security to have data privacy. But data privacy's focus is slightly nuanced and different. Data privacy is really looking at the data that's collected, how it's processed, who it's shared with, how it's used. What is your lawful reason for why you have that information? So it's not as much about securing it. It's more saying, okay, I have this information. Why do I have it? Am I allowed to have this information? And then what am I allowed to do with it? Because we could have all the security controls in place, but not have a lawful reason to have that data and still have a legal issue under the new regime of these data privacy laws. So if we go to the next slide, we're talking a lot of times about the data security landscape in the United States. And we've had data breach notification laws on the books for decades. We have a lot of robust discussion around that space. But where we're seeing the landscape shift, and I don't mean shift in the sense that cybersecurity isn't still 100% relevant. It really is. We see breaches every day. We see those threats and vulnerabilities evolving as the technology evolves in there. But we're seeing this shift. And the shift is that data privacy, data protection is now going to be an obligation on businesses. It's going to be an obligation in the states, at both the state and the federal level. And then internationally, with laws like the European Union's General Data Protection Regulation and many other jurisdictions, we're seeing these proactive requirements come into play around data protection and data privacy. And we're going to talk through a lot of those foundational principles today, because the CCPA and the CPRA is really building on a lot of the same concepts that we see across all of these laws. So I'll kick it back over to Sarah to talk through a little bit about what we're seeing here on the US side on the next slide, before again we dive more specifically into the CCPA.
Thanks, Jordan. By way of background, there is no comprehensive federal privacy law in the US, and this is contrary to how data privacy is regulated in a number of other countries. Instead, the US has a patchwork of privacy laws and regulations, most of which are at the state level. At the federal level, you will see certain laws that are more focused on industries where the data is regulated. For example, businesses in the healthcare sector are subject to HIPAA, in the education sector are subject to a law called FERPA, and in the financial sector are subject to the Gramm-Leach-Bliley Act. As Jordan mentioned, every state has a breach notification law, which requires notification to individuals and in some cases regulators when certain categories of data are disclosed to an unauthorized recipient. Those categories do vary by state, but generally include things like social security numbers, bank account numbers, credit card numbers, and a few other categories of sensitive information like biometric data. In addition to those breach notification laws, certain states have passed comprehensive data privacy laws that protect personal information, which is a much broader subset of data. That also is defined by each of the states that have passed these comprehensive data privacy laws, but often includes identifiers, contact information, that anything really that can be reasonably linked to a person or household. So things like email addresses and IP addresses that wouldn't necessarily be protected by those breach notification laws or some of those other federal laws that I mentioned are now being protected by those state level laws. Today, we're going to focus more on California's comprehensive data privacy law, but like Jordan said, many of the other laws that are popping up are very similar to the CCPA and have similar privacy rights. And I also want to just focus on the fact that every business should not lose sight of the fact that there are a number of different laws that are popping up in different states. And so they need to take stock and understand whether those laws apply to them. On the next slide, we have a poll question. And this question, if everyone could just answer yes or no, and this will help go towards CLE credit. Is there a general omnibus federal privacy law in the United States? Yes or no?
This question was clearly written by a lawyer.
General omnibus, for sure. Okay, I think we can move on. Do you want to show the poll question answers, Victoria? Nope, looks like most of the respondents answered correctly, no. Although in other countries, like I said, there are some more federal comprehensive laws. Moving on to the next slide. This slide talks a little bit about the why. Why should we invest in a data privacy and cybersecurity law program when there's so many other competing priorities of our organizations? And there's a few recent trends that reinforce the importance, in my opinion, of focusing increased attention and investment in this area. The first is increased activity from state attorneys general. Many of the attorneys general have signaled that data privacy is a significant priority. And importantly, they're not just saying this in guidance, they're actually opening up a lot more enforcement actions and issuing increased penalties in amounts that are drawing a lot of attention. The FTC, the Federal Trade Commission, has also indicated that this is an area of priority and that there is going to be increased attention as well. The FTC has broad authority to protect consumers from fraudulent, deceptive, and unfair business practices. The FTC can investigate privacy-related practices and bring enforcement actions for violations. And we are seeing the agency utilize this broad authority on a larger scale than they previously had, especially with data processing activities that the agency sees as potentially harmful to consumers. For example, generative AI, like things like ChatGPT, is an area where they've signaled that they're going to be increasing their attention, and also consistent with some of what we're seeing at the state level, making sure that those disclosures to consumers and things like privacy policies are accurate is another area where there's a lot of attention. Also, in addition to those attorneys general, we're seeing the creation of separate agencies who are responsible for enforcing comprehensive state data protection laws. For example, in California, there's a new regulatory agency called the California Privacy Protection Agency, the CPPA, that was created to implement and enforce the CCPA. They have dual authority in certain areas with the California AG's office, but we do anticipate that this will be an agency that plays a very active role in enforcement of the CCPA, obviously. And finally, the impact on businesses' reputation is becoming more and more of a reason to invest in data privacy. We're seeing consumers become more cognizant of their data privacy rights. And as a result of this increased awareness, we're seeing that privacy breaches are starting to take more of a toll on consumer trust. We're also seeing more and more class action litigation following breaches, even relatively smaller breaches. And finally, as consumers' awareness is growing, we're also seeing a lot of more complaints to agencies and data subject requests that are submitted to businesses. So on this please go ahead.
With that, we're going to dive into really taking a snapshot on what's going on in the United States right now, and then dive into the California components of this. And I always want to put a little disclaimer. We literally have to check this on a daily basis because it is evolving so rapidly in the US. I feel like every day we see a new state that's either considering or has adopted, or the governor is about to sign a bill to go into effect. So this is definitely an area that I would say you want to make sure that you are checking regularly to see as things are evolving, so that you can be prepared for what is becoming these sort of rolling deadlines that we see in the United States. So California has been around since 2020, but the CPRA, which is the new iteration of the California Consumer Privacy Act, went into effect January 1st of this year. And as Sarah mentioned at the top of the webinar, its enforcement deadline is July 1st of this year. So that means that the California Privacy Protection Agency, which is now charged with enforcing the California privacy laws, will be able to start enforcing as of July 1st of this year. And you can see that as we sit here today, there's two laws that are currently in effect. So it's California, which is the focus today. We also have Virginia that's been in effect since January 1st of this year. For the remainder of 2023, as it currently looks, we have Colorado and Connecticut that are going to go into effect July 1st. So coming up here in less than 30 days. And then Utah will go into effect December 31st of this year. Now, most of these laws do have some form of a cure period, whether that's 60 days or 30 days. It's important to note that California has gotten rid of their cure period, meaning that immediately upon their identification of any issue, they can move forward with enforcement. But you can see here, Colorado, Connecticut, they each have some form of a 60-day cure period. But those cure periods often end at a specific time. So they're intended to give a little bit of a buffer over these first few months of enforcement, but they're not intended to sort of last in perpetuity to give businesses that cure period to come into compliance. So this is a nice snapshot of what we currently have on our plate in 2023. There's 6 months left. Who knows what could happen, but let's move forward to the next slide. We have a poll question before we get to that next slide. So true or false, currently in the US, only the California privacy laws are in effect. So while everyone answers that, we'll move on here to the next slide to talk about 2024, and then we'll bring up those poll results after this slide. But here is a snapshot of what we have currently on the books, 2024 into 2026. This slide is going to change. I will give you that because we are seeing a lot of movement, and we expect over the next 2 years to see more states be put on this slide in some form. But right now, we don't have anything in early 2024. The first one coming down the pike is Montana in October 1st of 2024. And then the rest are 2025 and 2026. So this gives everyone a little bit of time, a little bit of breathing room to come into compliance. Similar to the laws that we saw that are going to be coming into effect in 2023, we do have these, somewhat cure periods or written notice periods where it's not really a cure period per se, but it's that they're going to give you 90 days written notice of any issue, 60-day written notice or 30-day, depending on the state, to come into compliance with those laws. And so what's important to recognize here is we're just seeing states get added on in the list of privacy laws that you're going to potentially have to comply with. And I will say one of the first things you want to do, and we'll talk about this specific to California, is do I need to comply? Because a lot of these states have different carve-outs, different approaches, different applicability triggers. And that's where I think you really want to be very close and pay attention initially with these laws to see if they're going to apply to you. So let's pull up the poll results to see where we are. So currently in the US, only California privacy laws are in effect. False is the correct answer. So well done, group. Great to see that, as we head through here. So let's move on and talk a little bit about what's going on and what's to watch for. So this is another slide that I will preface is going to change, and frankly, could change in the next couple of days. Florida, Texas, Oklahoma all have movement currently right now. Florida is waiting the governor's signature, so we do expect to see that get to that final stage in the near term. Texas is past the legislator. It's in reconciliation period, and that's where they're sort of looking at the differences between the Senate and the House versions. And in Oklahoma, it passed the House, it's being sent to the Senate. I've seen a couple of states pop up in the chat there. Like I said, this is evolving so rapidly. There's also nuances. Some of these states are looking at very specific sort of nuanced privacy laws. You can see Florida's more of a digital bill of rights, whereas some states are doing more of that general privacy approach that we see in California. So it's important when you're tracking these different ones to be mindful. Are we talking about a more generally applicable law? Are we talking about something that's more nuanced, more specific, or sort of only impacts one industry? So that's sort of the state of the US state privacy law and where that stands. I think it's really interesting when you're looking at the laws that have been adopted to date, that you're looking at really candidly what's on the line. For many companies, understanding the penalties, the fines is a necessary step to free up resources, whether that's freeing up individuals to focus on privacy, whether that's freeing up budgetary resources to devote to privacy. It's important to be able to demonstrate the potential monetary impact of these laws. So outside of California, the laws that have been passed to date do not include a private right of action. And so what that means is that in the event that any action were to be taken against companies under those different state privacy laws, it would be it would be the Attorney General or another agency that's going to be enforcing that. And an individual consumer is not necessarily going to be able to bring an action under these laws. I'll be very clear, there could be other actions that could be brought that sort of have privacy nuances to them, but under these laws. California is an outlier right now in that it allows a private right of action for security breaches. And there's some nuances in sort of how that's identified. So there is that private right of action for security breaches, but there is not a private sort of general private right of action for violations of the CCPA, the CPRA more generally. This tends to be private right of action tends to be a real sticking point. We've seen it both at state laws as well as the federal level as to whether or not a law gets passed. So it's definitely something to be watching as to whether or not these laws include a private right of action, because it obviously can open up things like class action lawsuits can increase exposure there. Outside of the private right of action, most of these laws have some form of a monetary fine that is attached to a violation. Most of them are per violation, which could mean, each time I click on the website, it could mean each user that clicks on the website. There's a little bit of open-endedness as to how those might be calculated or how they could leverage them to be calculated. I'm not going to go through all of them. You'll have these slides afterwards and can look at them, but you can easily see that, if you're looking at your user database, you're looking at how many individuals you're interfacing with, the personal information you're collecting. These per violation fines that usually range, between 5,000 to 7,500 per violation. California has some nuances and a little bit more, detail on that. That can add up quite quickly. So I think it's important just to recognize what's on the line, what's outstanding, and what your business could be exposed to under these different state privacy laws. So everyone likes a quiz. So we'll go to another poll question. This is a yes or no. All of the US state privacy laws include some form of a private right of action. So hopefully you have a photographic memory and can remember that slide before. Let's go ahead and bring up the results. And while we're doing that, I will turn this back over to Sarah to dive into the CCPA.
Great, thanks, Jordan. And it looks like most of the polls were correct that only California has that private right of action, and at least currently those other states do not. Moving on to the next slide. There's some information about applicability of the California Consumer Privacy Act. So the first question really that everyone should be asking themselves, or likely has already asked themselves, given the fact that this law became effective a couple of years ago and was just recently amended in January, is, do I even need to worry about this? Businesses should obviously focus on California, as well as looking at those other state laws that Jordan just mentioned. And the first thing I want to point out is that the CCPA has an extremely broad threshold for applicability, much broader than some of those other laws that we just talked about. The CCPA applies to nearly all for-profit commercial entities that do business in California, regardless of whether the business has a physical location or an employee in California, provided that they meet one of those three thresholds that are on this slide. And the first threshold seems to bring in a lot of businesses, so I'll talk about that first. If an entity does business in California and has an annual revenue of $25 million or more, there is a very good likelihood that the organization needs to comply unless they meet one of the statutory exemptions. In part because doing business in California, that particular piece of the equation is a fairly low bar. That basically means that you're selling or marketing products in California or working with employees in California or vendors. It doesn't necessarily, like I said, mean that you have a physical location or employees in California. So that revenue threshold plus doing business in California really brings a lot of national and international companies within the scope of the CCPA who might not otherwise be thinking about California laws because they don't have a very large presence there. But businesses with lower annual gross revenues aren't necessarily off the hook. And they also need to look at these next two prongs to see if their data processing brings them within the applicability of CCPA. So are they buying, receiving, selling, or sharing personal information of California residents for more than 100,000 consumers, households, or devices within California? A lot of companies that might not necessarily meet that revenue threshold do find themselves collecting sufficient amounts of information about California consumers, which includes employees. And then third, and this is, like I said, an or threshold. Do they derive 50% or more of their annual revenue from selling consumers' personal information? I do want to point out that the CCPA, as amended recently in January, includes employee information. So if a business has a lot of California employees, that information should be considered when you're looking at volume of data. It also includes business to business data. So not just data that they're collecting directly from consumers, also data that they're collecting on behalf of other businesses. Very quickly, there are some important exemptions that should be factored into that analysis on whether CCPA applies. First of all, nonprofit businesses are exempt from the CCPA. It's important to know that there are sort of common branding and ownership factors that weigh into whether you can take advantage of that nonprofit exemption. So for example, if a nonprofit is owned entirely by a for-profit or entity or has affiliations with a for-profit entity, they might not be able to take advantage of that exemption. Another, area that could, be something that weighs into the applicability consideration is whether you are dealing with data that is carved out of the CCPA. So for example, if data is regulated by other state or federal laws, like protected health information under this regulated by HIPAA, that data is carved out of the CCPA. Clinical trial information is carved out as well as financial information that's regulated by the Gramm-Leach-Bliley Act, and consumer reporting information regulated by the Fair Credit Reporting Act. Those are a few examples of data that's carved out. Importantly, though, that those exemptions do not apply to the entity entirely. So I work with a number of covered entities and business associates whose protected health information doesn't necessarily need to comply with the CCPA, or how they protect protected health information is regulated by HIPAA, not the CCPA, but they have a lot of other information like employee information or information that they're collecting on their website that will be applicable to the CCPA, and they do need to consider the CCPA when they're developing their privacy programs around that data. On the next slide, it's sort of the next level of analysis, which is really what information do I have that applies, that I need to worry about the CCPA for. Personal information has an extremely broad definition. It applies to information that identifies, relates to, describes, is reasonably capable of being associated with, or that could be reasonably linked directly or indirectly with a particular consumer or household, provided it's not part of those, carve-outs like PHI. The definition, like I said, is very broad, includes identifiers like IP addresses, contact information, email addresses, names, as well as some of those more sensitive categories of information like social security numbers and bank accounts, race, gender, sexual orientation, biometric data. Some of those more sensitive categories have heightened requirements and are considered more sensitive and require additional protections. But like I said, it's extremely broad. And again, want to reinforce that as of January 1st, employee data and business to business data is also included within that broad definition of personal information. Jordan, I'll kick it off to you for the next couple slides.
Thanks so much. I think the employee data piece definitely has thrown some businesses for a little bit of a loop, because up until that point, there really wasn't any other highly sensitive or personal information, and it sort of carved in this whole subset of information for businesses. So we've definitely seen a lot of businesses focusing extensively on that employment side in this first and second quarter of 2023. So definitely something to recognize. So when we're looking at the CCPA or the CPRA requirements, there are a number of them that have either been in effect for the last 2 years or are going to be going into effect under the CPRA. And a lot of these require proactive measures on the part of the businesses and the service providers to make sure that your governance of your privacy, your oversight of how you're using that data is in a compliant fashion. So like many of the laws that we see out there, there is this sort of inherent expectation that you're going to safeguard the data that you're collecting. We like to call this a sort of reasonable ATPS, or administrative, technical, and physical security controls. So making sure that you are putting in place really those baseline cybersecurity and security best practices around access, around encryption, around limiting permissions, et cetera, throughout your entire organization. And you don't want to forget about the physical, even though a lot of the data that we're collecting is in that digital environment. You might be sitting on a server somewhere, someone has a laptop, there still is paper out there. I like to remind people these laws are not just focused on the digital context, just so happens that's where a lot of that data resides, but paper is still something that you'll be thinking about. A big area that the CCPA focuses on is disclosures and notices, and then making sure that individuals have opt-outs. And we are going to talk a little bit about the Sephora case, which really focuses a lot on some of those opt-outs. When we're looking at disclosures, you're required to annually, every 12 months, update your privacy policy. Make sure that it is articulating accurately the data that's being collected, the way in which you're collecting it, the parties that you're sharing the data with, those third parties, the service providers. That is a big area under the CCPA, disclosing whether or not you are selling information or sharing information. And then a big update to the CPRA was some additional disclosures around sensitive personal information, biometrics, health information, making sure that you are being extra careful to lay out everything that it is that you're doing with that data. And then balancing all of this disclosure requirements with making sure that it's readable and it's accessible to these individuals. So the 50-page privacy policy might be incredibly clear and transparent, but might create some readability challenges. So it's always that balance back and forth when you're looking at those disclosures and notices. Additionally, we're seeing obligations to disclose things like cookie collection, the collection of data using those cookie and tracking technologies. Oftentimes, this is seen as a cookie banner that pops up. California still is an opt-out regime, meaning that you can presume consent unless someone opts out, but you do need to inform them that you are collecting that data at the point of data collection, and then give them that opportunity to opt out. And then opting out actually has to result in an opt-out, both with the business and then downstream to anyone that you're sending that information with. So that continues to be an area that I think both the technical and legal teams need to work hand in hand to make sure that that functionality is being built into any of those digital platforms where cookies and other tracking technologies are being leveraged. And then in addition to that, the California law does require recognition of a global privacy control, which is in essence a global opt-out mechanism that a data subject can put on their browser level, on their hardware level, to inform any website owner that they're going to visit that they have proactively opted out of the collection of their information through cookies. So GPC is sort of the shorthand for that. Again, it's an area that I think a lot of technical teams are still figuring out how to address, but definitely something that you want to put on that technical team radar to be building in that functionality on the website. California does require data minimization principles to be built into your overall compliance program. And what we mean by this is, if you don't need it, don't collect it in the first place. If you collect it, don't retain it indefinitely unless there's a legitimate reason to do so. There are certainly highly regulated organizations that have a requirement that data be retained for certain periods of time. But once you hit those data retention periods, actually going through, having that good data hygiene and deleting information that you no longer need is going to be incredibly important. And then having the policies and the documentation to back up that you do this, right? So it's not enough in today's world to do it. You need to be able to prove that you have done that. And for a lot of organizations, this is through policies and procedural documents. It's through maintaining artifacts to demonstrate that you have technologically sort of taken the steps that are required in those policies and procedures. We're going to talk about data mapping and data flows in a couple of slides when we talk about sort of operationalizing the program. But this is really, I think, one of the most important steps that an organization can take to start to understand how they're going to approach data privacy. Understanding how data flows into your organization, how it flows within your organization, and then how it leaves your organization, if ever, is really going to help you to identify the regulations that are applicable to you, the way in which you have obligations to that data. Do I have an obligation to the data subject? Am I 3 or 4 levels away from the data subject? Do I have contractual obligations that are flowing with that information? All of that data that you can collect around those data flows is then going to result in strategic decisions being made around your privacy program. Vendor contracting and oversight, I don't think we can say it enough in this space, but you are only as privacy oriented, you are only as compliant as your least compliant vendor. If you are bringing in a service provider, if you're bringing in a vendor, even if it is a cloud provider where you're just dumping data, they have no visibility into that information. The CCPA has flow down obligations that you need to pass on to those vendors, both contractually and then through a due diligence exercise to make sure that it's actually happening. And so it's really important from a contracting perspective that you have established really strong contracts around the CCPA requirements, what you're going to expect your vendor to do, what you are going to handle, and then that you've built in the mechanisms to go back and do that due diligence, especially for those more critical vendors, vendors that have access to that personal information, vendors who are doing critical functions for your business. It's going to be really important to go back and make sure that you have that ongoing demonstration that you're ensuring they're compliant. And then finally, this is sort of a requirement that's coming out of the CPRA and the new regulations, privacy impact assessments. This is something for those of you that have dealt with the EU's GDPR, it's going to sound very familiar because it's something that's expressly required under that law. But we're now seeing this come to the United States to the CCPA and the CPRA. And really, in short, this is building out a process to ask the teams, do we have a privacy impact by doing what we're doing, by building out the product we're building, by creating this certain functionality, by collecting this data? And if we do, are we taking steps to mitigate what's going on with that privacy impact? This is an area that we are looking and expect to see more guidance from the regulators in California as to what they're expecting, how detailed versus, what the steps are, what those mitigation steps are. But it's something that you should be thinking about because I find in working with teams, this is a challenging exercise if you've never gone through it. If you never asked these privacy questions, you never built that functionality into sort of your development teams, it's going to take some time to make it be part of sort of that daily vernacular. So diving into a couple of specifics, I want to talk a little bit about data subject rights and responses. It's important to note, I know we're talking about California, but these rights and procedures do vary by state, federal, and international law. The timelines to respond, the expectations to respond, the carve-outs, the exceptions that you're able to rely on. So this is an area that you really want to make sure that you're driving towards the specific law that you're looking at. But specifically when we're looking at California, we do have certain consumer rights that need to be addressed. So the first is disclosing what you're collecting, using, and sharing of that data, the sale of that data as well. You have to provide the user with the option to opt out of the sale or sharing of that data. And then we have other rights that you'll see mirrored in a lot of other privacy laws that are out there. We have access rights, meaning that an individual has the right to access the information and to know what you have on them. The right to restrict disclosure of that information, both in the sale or the sharing, but then also further disclosure. The right to correct information that's wrong, so making updates to that data. The right to request to delete data, although California does lay out a number of exceptions to that deletion. So deletion is not an absolute right. And oftentimes there are ways that businesses can maintain the data if they have a lawful reason to do that. Accounting of the disclosure of that information, and then knowing the categories of information collected or sold. And some of these rights can be addressed in your privacy policies, and then some of them are going to be addressed through specific data subject rights that requests that might come into your office. And so building out a process to address these rights, to field those rights, to then search your entire infrastructure to identify if you have this individual's information? And if you do, what information do we have? Why do we have it? What's our lawful reason to maintain it? Building all of that in is going to be really key. Under California, you have 45 days for the entire response, right? So not 45 days for your initial response. And in fact, we'll talk about some of the updated regulations. And then if you fall into an exception, which should be a rarity, you could push that out for another 45 days for a total of 90 days. What's really important to recognize is that oftentimes this is one of the fastest ways you as a business can come in front of the regulator, because an individual complains that you failed to respond to their data subject right request, or you failed to respond adequately. And two, this is an area that, in the abstract can seem simplistic. We get the request, we search our system, and we respond back. But searching your system is not as easy as typing it into a Google search bar, John Smith, and seeing what comes back. Oftentimes, it's going to take multiple different teams who own different systems, different databases, who are going to need to search and then confirm that the information they're getting back is valid. So it's important to be building in those processes and then testing those processes before you actually have to go live with an actual data subject right and response. So I'm going to talk briefly about the regulations that help provide some additional clarity under the CPRA. So just as a little bit of a background, we have the actual regulation itself, we have the law itself, which is the CCPA as amended by the CPRA. And then the law directs, originally it was the California Attorney General, and now it's the California Privacy Rights Agency, to promulgate regulations. And these regulations can be incredibly helpful to provide more detail and information specific to what's required in the law. So this is definitely an area that you want to make sure that you are looking at and referencing. I'm not going to go through everything. You can certainly take a look at the slides after we go through here, but I want to highlight a couple of key ones that I think are incredibly relevant. So when you get a DSAR request, you have to respond and confirm receipt of that request within 10 days. So we had that 45-day period. Well, it's actually 10 days to respond and confirm receipt. And then you have another 35 to actually complete the entire response. The DSARs now have a record keeping requirement, and you're required to maintain the records of a CCPA consumer request and response for at least 24 months. You're required to sort of implement reasonable security procedures around those records. And then there's specific things that you should be maintaining. And I actually think this is very useful for businesses. Prior to this, there's sort of this outstanding question. If I'm deleting someone's information from my system, does that also delete their request? And I think here we have a good basis to say, John Smith is deleted from our live database, he's deleted from all of that, but we can keep John Smith purely to demonstrate that we have complied with his request. We have an obligation to keep it for 24 months. And so this is going to be a great way that companies can use the law to help support them in demonstrating compliance with this. So we have another poll question before I go into the Sephora case. So true or false, businesses are required to maintain records of CCPA consumer requests for a minimum of 7 years. While everyone's answering that, I just want to briefly talk about the Sephora case, which is the first California Attorney General action that we saw under the CCPA. And so I think it's relevant for a number of reasons. One being the first is always going to put you in the news. But this is a really important case when it comes to understanding the obligations around opt-out and notifying individuals of data that's being collected on their websites. So just really briefly, Sephora installed third-party tracking software on its website so that third parties could monitor consumers as they shopped. It was never stated it was Google Analytics, but it seemed from the description to be very analytical. They were only providing analytics, creating profiles to target users with advertising. The third parties never necessarily, shared back personal information to Sephora. They were just placed on there. And basically what the California AG found was that that this was considered the selling or sharing of personal information to these third parties. And that because of that, Sephora failed to state that it was engaged in the sale of this information and provide users with an option to opt out of the sale of that information. So basically what this case really did was it said, even if you're using third parties purely for analytics, we are going to qualify that as the sale or the sharing of information. And then you as the business operating the website are going to need to provide users with an option to opt out of the sharing or sale of that information to these third-party analytic companies. In addition to that, the California AG also found that Sephora failed to honor these global privacy control signals. Again, those are typically at the browser level where a user has said, I'm opting out of the collection of my data. You don't need to show me a cookie banner or anything. I've already opted out of it at the browser level. There's a couple of key takeaways. We could talk about Sephora for an entire hour. In fact, I think it's a really interesting case. But the first is all businesses should be reviewing the use of any third-party tracking software that are on their platforms, their websites, etc. The California AG decision did allude to a potential safe harbor, saying that had Sephora identified this analytics tracker as a service provider, they would not have been considered the sale or sharing of information to a third party. And so reviewing your contracts to confirm if this party is a service provider could be a nice way to avoid having to state that you're selling or sharing data and then giving that option to opt out. This is also a really good reminder to review those privacy policies and the relevant disclosures to see if you have identified these third-party analytics providers as a sale of information. And then if you're using them, looking to see how you're going to be able to build in that functionality to opt out of the use of this information. And then finally, as I sort of stated, a couple of slides ago, these global privacy controls, which we're seeing in some other state laws as well, is something that the technological teams really do need to focus on creating mechanisms to acknowledge those signals, to recognize them, and then to push them downstream to any third parties that might be on the website. So making sure that you have identified global privacy controls, that you recognize them, and then figured out the way to push those signals downstream to your service providers, to your third parties, et cetera, to make sure that that data is not flowing down to other people if there is a GPC put on, is going to be really key. So Sephora really highlighted, I think, that sale and sharing functionality that we see, and that's a very specific CCPA nuance, the sale or sharing of data. We haven't necessarily seen that wholesale adopted across the country with all these new different state privacy laws, but it's something that's very specific to California, and the California AG really did signal that it's something that needs to be taken incredibly seriously if there's any collection on information that was there. I just saw a quick question that I'll answer before I kick this back over to Sarah. So the question was on what bases was the third party not found to be a service provider. So one thing was that the third party was not identified as a service provider in any of the contractual documents. The other piece was that the third party was really making its own decisions around the data usage. It wasn't really collecting it on behalf per se of Sephora. Yes, it gave some information back, but actually that sort of encouraged the definition of a sale. But it was that this third party was then doing whatever they wanted with that data, and they were able to identify the individual. They were creating profiles and then leveraging it on their own behalf. So it was sort of their ability to go beyond what they'd originally collected the information for that created that distinction. So I know we're coming up on time. I'll kick it back over to Sarah to talk a little bit about strategies for implementation.
Thanks, Jordan. And I think just adding on to that Sephora case and those third parties and identifying them as service providers, that is a great question, and a significant area that organizations should really focus their attention on when they're thinking about how to mitigate liability under the CCPA. There's specific contractual provisions that do need to be in place with those service providers that are outlined in the CCPA. regulations, and every organization, I highly recommend going through your contracts with especially your significant service providers who are collecting or analyzing personal information on your behalf, and make sure that those limitations and provisions around how data can be used and disclosed are in those contracts. Up until this point, we've covered really a lot of ground in terms of what's required by the CCPA, covering quite a few recommendations on how to comply with the CCPA, including those third-party contracting, opt-out mechanisms, disclosures. Kind of taking a quick step back to talk through strategy and compliance. These laws can be very complicated, but compliance doesn't need to necessarily be complicated, and you want to simplify it as much as possible and develop a program that's really tailored to your business based on the size of your business, the industry that you're in, and the sensitivity of data. There really is no one size fits all compliance program. And the programs really should focus on these three pillars. First of all, the people who are working with your personal information, they're going to be the frontline compliance team. It's absolutely essential that they understand your program, how to implement the program, and ways that their actions can help to mitigate risk, because those employees really are your biggest advocates, or in some cases, your biggest liability. Also, in terms of documentation, that's another sort of key risk of a lot of these compliance, these privacy laws and regulations. We want to make sure that we're documenting all of the great administrative, technical, and physical controls that you have in place, so that if a regulator were to knock on your door to audit you, you can show them exactly what you're doing and documenting your compliance to hopefully just reduce the risk of any enforcement action. But equally important is documenting compliance so that the people within your organization understand how to implement the concepts, make sure your policies are actionable and really tailored to how your data governance strategy and program and your specific team. Because just having a bunch of policies that say that you're going to do certain things and that you take this seriously isn't really that helpful in terms of actually helping to make sure that you're doing what you need to do to protect data and to comply with the law. And finally, businesses should think strategically about how technology plays into your compliance program. Think strategically about how your back-end infrastructure is informing how data flow is happening, and how your within your organization access controls, as well as limitations on sharing information with third parties. And data minimization especially is such an area where making sure that you have the back-end infrastructure is very essential and important, because having that data deletion and retention policy in place is something that previously was focused more on how long do I have to keep data to comply with the laws. And now it's really, we need to look closely on, can we delete data even if we, once it's beyond that legally required time period. In terms of the next slide, thank you. Jordan, we're really run out of time. Want to again focus on sort of the importance of data mapping, knowing where your data is so that you can protect it. And we really highly recommend engaging a third party or yourself doing a data inventory and mapping, doing some risk assessments. And then Jordan, do you want to say a few words to close us out, since it looks like we are almost at the top of the hour?
No, I think that's great. And I think one thing I just want to highlight that Sarah said was that it feels very complex. It feels very overwhelming and almost like Pandora's box when you start to dive into not only the California privacy regulations, but also just what's going around all of the United States. And I think my recommendation is always look for the commonalities, look for the opportunities to synergize across your different operations. There are ways to step through this. A lot of it is gathering information, understanding how your organization wants to approach this. and then starting somewhere. The worst you can do is sort of put your head in the sand, not focus on it. It's here. It's something that businesses need to start to comply with, but slowly building out a program is much better than waiting for a regulator to come knocking on your door to then address that. So really appreciate everyone joining us today. We will make sure that everyone has a copy of these slides, as well as the few here that we weren't able to get to. But we really appreciate you joining us today. We hope you've learned a lot. And Sarah and I will make sure everyone has our contact information so you can reach out if you have any additional questions.
Thank you all for joining us today. We will now end the webinar.